Trump's attorneys have been making some really crazy filings lately. Some of them are just completely nuts. I was going to do this yesterday, but then the whole target letter thing dropped and I had to talk about that. But let's get into it today. My name is Matthew. Welcome to Matthew Land. All right, first, let's talk about the really crazy ones. This happened in Georgia. So, in Georgia, they had a special grand jury. This grand jury, they don't look for indictments or anything like that. They're just there to find evidence. That's it. Well, Trump's team made a filing with Georgia's version of a Supreme Court, asking to have all the findings and all of the evidence that the special grand jury found to be completely thrown out. This includes the recording of the phone call where Trump said to the Secretary of State, "I only need 11,780 votes, which is one more than I need." That is really condemning. When you're down by 11,779 and you're asking for 780, yeah, that is definitely election interference. That goes to the heart of our democracy, and you're trying to have that specifically not be heard? No. No, I don't care who you are. If you're a Democrat or a Republican, that goes to the heart of our democracy. No. They were asking to have everything thrown out. They heard from Rudy Giuliani even. They heard from a whole host of people. One of their findings was literally that there was no election interference, that the vote tallies were 100% accurate. They were asking to have all of that thrown out. Another thing that they were asking was to have Fulton County District Attorney Fani Willis be taken off the case. And she's the one who was looking at all of this. And so this was filed with the version of the state Supreme Court, and their ruling was one word. One word only. Denied. That's it. That's great. You're asking to subvert democracy. You're asking to be the President of the United States. You're asking to be the Chief Law Enforcement Officer. To defend the laws of the United States of America. That's part of the oath of office. And you're trying to get rid of one of those laws, to subvert one of those laws. That should be denied if that's how you're trying to get into office. No. Now, let's talk about Florida. They're trying to get a timetable for when the trial is going to start in Florida, and we do have some news on that finally. I've been waiting on this for a while. I really wanted to hear about that, and it was kind of hard to get some information on that because of the whole target letter thing, but I did find some information. Now, again, it was Judge Cannon. Judge Aileen Cannon was appointed by Donald Trump. He was actually posting on True Social that how great of a judge she was and she loves America, and basically saying without saying, "Hey, judge, do me a solid." She made a lot of rulings while they were trying to go through all the documents during that search warrant at Mar-a-Lago that were going against the government, that the appeals court smacked her down really hard. And this is a very conservative appeals court. Now, immediately after the indictment that was given to Donald Trump, right after that, all of the unclassified information was given to Trump's attorneys. And they said that as soon as Trump's attorneys got their security clearances, they'd give them everything else that they could. And this is highly irregular. You're actually not required to give discovery material until pretty shortly before the trial begins. There are some things like witness testimony and stuff like that you don't even have to give until after the trial started. You don't have to give that until shortly before that witness is even talking. So that's pretty rare, and that's one thing that the government's trying to do, that the special counsel is trying to do, to say, hey, judge, we're ready to go. We want to get this going as quickly as possible. We're not trying to interfere with the election. We're not trying to do anything. We're not trying to do anything. We just want to get this going. Quick and speedy trial. That's what we're trying to do. Now, just as a note, quick and speedy trial, that's not just for the defendant. That's for the people as well, for the prosecutors as well. They want to get things done. It's for the people. They want, it's the people versus. And so the people want, the government wants, if someone's guilty of doing something, I want justice to be done as quickly as possible. I don't care if you're a Democrat, if you're a Republican. I don't care if you're Biden, Obama, Trump or Clinton, Bush, whoever. I want justice to be served. I don't care if you're no political affiliation at all. If you killed someone, robbed a jewelry store, got a traffic ticket, justice needs to be served. So that's the whole quick and speedy trial thing. And so Judge Cannon, she initially set a trial date for August 14th, which is a quick and speedy trial. Now, Florida's got something that they call the rocket docket, which is basically Florida's known for having really quick trials. And so August 14th is pretty quick. Now, the government actually said that August 14th is pretty quick. That's actually too quick. In an issue of fairness for Donald Trump and his attorneys, because everyone needs to get security clearances, and there's a lot of evidence here. Let's be honest. There's a lot of stuff that it'd be more fair for Donald Trump if the trial was a little bit later. And so they suggested that the trial was set back to December 11th. They said that it'd be more fair. Now, if this was a political prosecution, then you'd think that with all this, Trump's team needing to get security clearances, with everything that needs to happen, all these documents can only be seen in a secured location, with everything. You'd think that August 14th, yeah, let's hurry up, let's get it done. You'd think that they'd want to do that, so it'd be harder. But no, they said, let's do something so it's more fair. Let's push it back so you've got a better chance of defending your client, of defending Donald Trump. And that's what they did. Now, Judge Cannon also, she isn't really all that familiar with classified documents cases, which is another reason that she said it for so quickly, which a lot of federal judges don't deal with classified documents cases. So that's kind of reasonable for her to be setting it so quickly. And so because they saw an opening, because the special counsel in the Department of Justice said, hey, let's be fair here. Let's push the trial date back a little bit. Trump's team saw an opening. They said, you know what? You're right. You're right. They didn't push a motion. They didn't argue. They didn't disagree when the trial date was set for August. But now they saw an opening. Now they said, you know what? We want to push it back until after the election. Until after November 5th of 2024. Now, here's a question. Here's a question that I've got. November 5th, 2024 is some magical day. It's magical. because on November 6th, 2024, that's the day. That's the day that you're going to be ready. Really? Really, dude? That's the magical day? I don't think so. I really don't think so. They straight up said that they won't be ready until that day. They said it's got nothing to do with the election, but it's got to do with when they're going to be ready. It's a magical day. Obviously, the Department of Justice pushed back on that. It's not a magical day. There's nothing magical about November 5th versus November 6th of 2024. Now, although they didn't have an exact response to that, they did say that Judge Cannon did say that she thought that the December date, now that thinking about it, was probably a little bit too soon. And Trump's team agreed. Obviously, that was one of the issues, that it was definitely too soon because there's 1.1 million pages of discovery. 1.1 million. And that includes over 1,500 pages of classified documents. There's also 3 years of security footage that was given to them in discovery. Now, that does sound like a lot, but it's really not as bad as it seems. And here's why. The Department of Justice's special counsel gave them what they're calling a roadmap. They're saying this is specifically what we're going to be using. Exactly. They marked the video footage of when the documents were moved, everything that they're going to be saying that they're going to be using in trial. All the documents specifically that they're going to be using in trial, as far as the classified documents and the unclassified. And also the 1.1 million, that sounds like a lot, but it's not like, you see in movies how they're like, okay, we're giving you discovery, and it's like box after box after box of papers. It's not like that anymore. You don't get buried in discovery documents. It's all transmitted to you electronically, and then law firms are able to use AI, and they search electronically for what they need specifically. This really isn't uncommon for large cases to be given over 1 million pages of documents in discovery. It happens all the time. Now, you've got big law firms that handle this. They're used to it. It's really not that big of a deal. It sounds like a lot, but it's really not. Now, another thing, we've got to keep in mind that this Judge Cannon, she was smacked down a bunch of times by the appeals court, but she said multiple times that she was really skeptical of the government and what they were trying to do. And so it's not difficult to believe that their roadmap, she's probably going to think that there's going to be more to it than just what they're saying. And I can understand that. I can see that. Regardless of what side of the aisle I'm on, I can understand that there's what they're going to use, but there's also things that maybe they're not going to use that's exculpatory evidence that may help Trump. I don't know. I try and see both sides of an argument, and I don't know. That is possible. So I can definitely understand that. But there's one thing that I want to keep in mind that I've been thinking about a lot. I really have. And I think it's really funny. Now, with all this, after Mar-a-Lago and as soon as that happened, Trump's lawyers immediately said that we want to see all this. And so they said, we want security clearances, like right away. And like this whole time, they've been saying, we need security clearances. And we've been waiting for them to get security clearances, for them to view all this. And they've never argued that they don't need security clearances to view these classified documents. This case is about classified documents. That's like a huge part of this case, is classified documents. Now, if you're defending a classified documents case saying that Trump automatically declassified everything, that's what he's been saying all along. I automatically, as soon as everything left the White House, automatically declassified. So if everything was automatically declassified, why do they need security clearances to look at this? Things that make you go, They've never argued this point. They've never said, we don't need security clearances because this has been declassified. I'm really waiting for this to be argued. Are they going to argue this in court, saying, hey, this has been a bunch of BS because we've been required to get these security clearances. We didn't push back because it was going to bring up all this, it was going to delay all this, and we didn't want to deal with all that. But I don't know what they're going to do, but they have not argued this. This has not been litigated. This has not been pushed back on at all, ever. That why do they need security clearances to view all this information that was automatically declassified? I wonder. What side of the aisle are you on, Democrat or Republican? If everything's been declassified, why do they need security clearances? It just, without any bias at all, just look at it through unfiltered eyes. Just remove all of your preconceived notions. Just look at it as the facts and nothing but the facts. I automatically declassified everything. I need a security clearance to view this. Those are conflicting facts, are they not? I think it's kind of funny. I really do. But now the judge did seem sympathetic about how complex this case is, as Trump's attorneys were arguing, which it is a relatively complex case. But she also seemed sympathetic to the government, saying that, we try classified documents cases all the time. This is under the Espionage Act, and all that means is that it's the removal of secured information. It's not necessarily that you're a spy. It's that you took classified information that you're not entitled to. That's all it is. And we try those cases all the time. Very recently, everyone heard about Jack Tahira. I can't pronounce his last name. The guy from the Air Force who took classified information and put it on some gaming server. That was tried under the Espionage Act. It happens all the time. So this really isn't all that unusual. So Judge Cannon was sympathetic to that side of the argument as well. And with all that being said, the judge said, we need a timetable. She said that we can't just do this for some point in the future, some unknown date. She told Trump's attorneys, we need a timetable. We've got to do something here. And she also questioned the prosecutors as to whether or not there were similar dates that were set in such a short period of time. And they told the judge that this really isn't as complex as it seems, and that's why there's no need for such a lengthy delay. That's why they're pushing for a date in December. They also rejected the insinuation by Trump's attorneys that there's any sort of political influence. The whole purpose of having a special prosecutor is to specifically avoid that. Merrick Garland, the Attorney General, said as soon as Trump announced that he was running for president, which happened right after the last election. I mean, he was obviously waiting for that to happen. It was like a week after that election when he announced. So let's be honest, it was, I mean, to me it seemed pretty friggin' obvious. As soon as that happened, Merrick Garland said, in order to avoid the appearance of any sort of influence at all, I'm appointing a special counsel to look into all this. And he even went so far as Jack Smith hasn't even been in the country in years. And so that's the whole point of a special counsel, is to get someone who's outside of the government. And actually, all of the investigators, everyone who is on that team, none of them are political appointees. And that's the whole point. That's exactly what you want, is to do that so that you avoid any form of political influence. They also told the judge that they were treating Donald Trump just like he was any other busy citizen, regardless of the fact that he's campaigning. He's busy. Yes, he's busy. But there are a lot of busy people out there. There are a lot of people who have to travel a lot for work. Just like Donald Trump is going to be traveling a lot for his job, which is campaigning. And so that doesn't excuse him from the law. It's no excuse for breaking the law. You can't break the law and say, oh, you can't charge me for anything because I'm running for president. You're not above the law in this country. Nobody is above the law in this country. In fact, here is specifically what Mitch McConnell said.
President Trump is still liable for everything he did while he was in office as an ordinary citizen. Unless the statute of limitations is run, still liable for everything he did while he was in office. Didn't get away with anything yet. Yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
Now, Judge Cannon did say that a December trial date may be a little bit too soon, but she didn't actually set any date for when the trial would begin. It sounds like they're probably going to meet, the Trump team and the special counsel, in November to discuss this a little bit more. But it's kind of wishy-washy. She didn't really say anything definitive as to whether or not that's going to happen. She did say that she's going to make a decision promptly. Now, as far as legal terms go, there are a lot of things that are specific that mean something. Promptly is not one of them. So listened to and seen and read a lot of political scholars. I actually know a couple of lawyers, and I've talked to them, and I've asked them about it, and promptly doesn't mean anything, but they've all said that they're expecting, based on that language, typically within the next week or two. So, God, I don't know how many times I've said this, but stay tuned. Again, my name is Matthew. This has been Matthew Lynn. Please like and subscribe. I'll keep you updated. I'll catch you next time.